That is people of the state of Michigan versus Chad Allen Gober. Will the parties please introduce themselves for the record? Mr. Stevens.
Andrew Stevens on behalf of the people.
Edward Zane on behalf of Mr. Gober, Your Honor, he's present to my right.
And sir, you are Chad Gober, is that correct? All right, thank you. This is time set for a preliminary examination today. Mr. Stevens, how we proceed?
Your Honor, and speaking to Mr. Zane, it's my understanding that Mr. Gober, as well as the people, are going to waive their respective rights to the preliminary examination. This matter will be bound over to circuit court as charged.
That's a fair statement, Mr. Zane.
It is.
This is an unconditional waiver and negotiations are to continue.
Correct. Judge.
Mr. Zaney, may I inquire of Mr. Gober of his waiver of the preliminary examination?
You may, Your Honor.
Mr. Gober, you understand you have a right today to a preliminary examination within your date of arraignment, today's date. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Edward Zaney. He'd be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it is your wish today to waive your right to a preliminary examination today, have this case bound over to circuit court as charged where negotiations are going to continue. Is that your wish and intent to waive your right to preliminary examination today?
Your
Honor. Mr. Stevens, do the people also waive their right to preliminary examination?
People do, Judge. Thank you.
Right. Thank you. I find the bind over with negotiations to continue to be knowing, voluntarily, and accurately made, and I will provide the documentation for bind over for the parties to sign. I can find it.
Here, we both provide our signature on that document.
Thank you. And then Mr. Stevens.
I was kidding.
You was a slave.
Yeah, of course. Back when I thought I was going to be a professional athlete.
All right, so I'm in possession of the bind over document signed by all the parties. I'll indicate that the examination has been waived on today's date, which is the 21st. Anything else to come to the court's attention before the court binds over on signature, Mr. Stevens?
Nothing from people.
Mr. Zaney.
Nothing from defense. Thank you, Your Honor.
All right, you're all set. Your time in district court is done. You'll get your next date from Mr. Zaney in circuit court. All right, sir. Thank you.
Thank you, Your Honor.
You too.
Who's next, Mr. Stevens?
We can take Ms. Donnelly's client.
Messiah Selassie?
Yes.
How are you, Ms. Donnelly?
Doing well, Your Honor. Thank you. How are you doing?
Pretty good. All right, so we're on the record in docket 24, and docket 23-03357. That is people of the state of Michigan versus Messiah Selassie. I might have to repronounce that. Will the parties please introduce themselves for the record? Mr. Stevens.
Andrew Stevens on behalf of people.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Mosiah Selassie, who is present standing to my right.
And sir, it is Mosiah Selassie, is that correct? Thank you. This is the time set for preliminary examination today. Mr. Stevens, how are we proceeding?
Your Honor, there will be an examination. What there will be, however, is a request to adjourn from the people. This was something that was already discussed with Ms. Donnelly via Ms. Wilson. As the court can very clearly see, I am not Ms. Wilson. She had a personal matter that came up. I believe it was Wednesday afternoon that prevents her from being here. However, she provided me very detailed notes And as it relates to this, and also my preparation of the case for today, I can provide to the court the following information. This case is a charge of CCW, carrying concealed weapon, specifically a pistol. It is a one witness examination. The one witness subpoenaed on behalf of the people is Officer Kilborn. And according to Ms. Wilson, Officer Kilborn had emailed Ms. Wilson earlier this week to indicate or to inform her that he was out of town this week and would be unable to attend the scheduled date and time for the examination, upon which Ms. Wilson notified Ms. Donnelly that we would be seeking an adjournment. And so for that reason, the people are requesting an adjournment of the examination.
Thank you.
I certainly wish I could give you more details, but that is what Ms. Wilson provided me. Wasn't on that email exchange.
Right. Ms. Donnelly.
Thank you, Your Honor. Yes, that is accurate. That was communicated to me by Ms. Wilson earlier this week. We cannot stipulate to the adjournment. It is time set for his preliminary exam within 21 days. This is right. So, Your Honor, we would just object. Thank you.
Thank you. I find just cause to adjourn for the people's inability to proceed, mostly based on the contact between the subpoenaed victim and the subpoenaed witness and the prosecutor's office, indicating that there was a conflict. So the law enforcement stayed in touch. I find just cause so Mr. Selassie does not have to waive any rights today concerning this matter. And then we will reset the prelim. I think we're probably looking for 2 to 3 weeks out.
I don't have an understanding his timeline. That seems appropriate. Nothing suggests that this is an extended absence.
And not knowing that the timeline of the officer, we'll set it for 2 to 3 weeks out.
Will July 11th at 8:30 work?
July 11th at 8:30.
That's fine, Your Honor.
All right. So, Mr. Selassie, we've adjourned this based on the law enforcement's inability to be here today because of a previously scheduled conflict. We've set this for July 11th at 8:30. I found just cause, which means that you don't have to waive any rights in this matter, and we'll just set it for that date. All right, sir?
Okay, thank you.
Anything else for the record in 23-03-357, Mr. Stevens?
Nothing from the people, Judge.
Ms. Donnelly.
No, Your Honor. Thank you.
All right, Mr. Selassie, you're all set. Thank you for your appearance today.
She here today? Well, so the answer to the question is no, she's not. So no, okay. Judge, we are going to be running Torres.
Okay,
Officers here, Mr.
Johnson's behind
Mr.
you.
Johnson's here, Mr. Torres is here, I believe the interpreter's here. Would you like to start that now, or would you, because I'm speaking with Ms. Wanji, I still have to speak with Mr. Palmer on 2 matters. Would you like me to try and address those?
Yeah,
before we
do
start?
those and then we'll
Okay.
start on Torres.
We don't want to bring up counsel more than I have to, but.
I can pay, but out.
Yeah, if there's anything to go.
There's
in
no
front of-
objection to that.
If there's anything to get to move, let's move it and then we can
Okay.
start the prelim.
So she's not here yet. Okay. Once you get here, you and I can have more of a conversation. Yes, okay.
All right, so we're on the record in docket 2400-470. I'm sorry, that's 2401-670. That is people of the state of Michigan versus Robert Collins. Will the parties please introduce themselves for the record? Mr. Stevens.
Andrew Stevens on behalf of people.
Mr. Silverthorne.
Good morning, Dwayne Silverland from the Office of Public Defender on behalf of Robert Dwayne Collins, who is not present and not here in court.
All right, thank you. This is the time set for 9 o'clock. It is now 9:25. And I do not see a Mr. Collins in the Zoom courtroom, physical courtroom. Based on the representations from counsel, it appears that the defendant has failed to appear today for the preliminary examination. Mr. Stevens, how are we proceeding?
Your Honor, at this time, the people would request a bench warrant, any bond posted be forfeited. Thank you, Judge.
Any comment, Mr. Silverthorne?
First, as to the request for a bench warrant, I'd leave it at the court's discretion, and I'd like to create a record of my attempts at contact.
All right, you may proceed.
Throughout actually last week and this week, I have been trying unsuccessfully to contact Mr. Collins, both by email and by phone. I did finally contact him by phone yesterday. We had a conversation. I was very explicit, not only that he needed to be here, but because I had not been able to talk to him about the case significantly, he needed to be here earlier than 9 o'clock, as I was. He is not here. This morning, again, I again sent out an email. I again sent a voicemail. They were basically duplicates indicating that if he didn't appear, the prosecution would ask for a forfeiture of bond and a warrant for his arrest to be issued. He very well may spend the remainder of this case until resolution in jail. He is not here. So I don't know what else I could have done, Your Honor. I have no explanation for why he is not here.
All right, so I'll issue a bench warrant and bond forfeiture for the non-appearance of Mr. Collins. Anything else for the record in 2401-670, Mr. Stevens?
Nothing from the people. Judge.
Mr. Silverthorne.
No, thank you, Your
All
Honor.
right, you're all set. Thank you for your appearance
Thank
today.
you.
Somebody.
Brought up Darcy.
Hill, Darcy Hill.
And Mr. Stevens, were you ready to go on Ms. Hill?
Yes, Judge, thank you.
All right, so we're on the record in docket 2400-470. That's people of the state of Michigan versus Darcy Hill. Will the parties please introduce themselves for the record? Mr. Stevens.
Andrew Stevens on behalf of people.
Ms. Donlin.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Darcy Hill, who is standing to my right.
Ma'am, you are Darcy Hill, is that correct? Thank you. This is the time set for preliminary examination today. Mr. Stevens, how we proceed?
And it's my understanding that Ms. Hill will be tendering a guilty plea to amended count 1, use of a controlled substance, specifically cocaine, MCL 333.7404, paren 2, paren B, 1 year and or $1,000.
What's that PAC code again?
333.7404, paren 2, paren B.
We'll amend the original count to the use of cocaine, which is a 1 year and or $1,000 pursuant to PAC code 333.7404, parents 2, parents B, with a guilty plea to the amended count 1. Is that a fair statement, Ms. Donlin?
Yes, only to add, it was discussed with me and Ms. Wilson, but they won't object to 7411 if she's eligible. That's my understanding. So yes,
So there's no objection to 7411 if eligible.
That's correct, Judge.
If eligible. All right, so Ms. Hill, that's your understanding, and we're going to amend count 1 to the use of cocaine. That's 1 year and or $1,000. And with a plea to count 1, there will also be a no objection to the 7411 status if found to be eligible by the probation department. Is that your understanding, Ms. Hill?
Yes.
All right. Ms. Donnelly, may I inquire of Ms. Hill of her misdemeanor advice of rights?
yes, Your Honor.
Thank you. All right, so you have in this use of cocaine case, you have 1 year and or $1,000, the ultimate penalty. You have the following rights in this misdemeanor case, and I'll walk you through those. All right, ma'am. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You're represented today by attorney Sarah Donnelly. She'd be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You have the right to have the court order any witnesses appear in your defense to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If you're pleased to accept today, you'll give up the claim. The plea was a result of anything that we have not placed on the record, any promises other than the plea agreement placed on the record, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. So since you won't be having a trial, you'll be pleading guilty instead. Is it your intent and wish today to waive your jury trial rights and plead guilty to use of cocaine?
Yes, sir.
Yes, all right, thank you. You may raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? I'm going to bring your attention, ma'am, back to February 22nd of 2024 at the offense location of 1219 North Martin Luther King. Were you present at North Martin Luther King on February 22nd, 2024? And at that time, did you use a controlled substance containing cocaine in it?
Yes.
Did you knowingly use it? You knew it was cocaine when you used it.
Yes, sir.
All right. Anything towards a factual basis, Mr. Stevens?
No, Judge, thank you.
Ms. Donnelly?
No, Your Honor.
I find the factual basis to be knowing, voluntarily, and accurately made. We will refer to probation. So probation will be down to see you. They'll develop a report, and then they'll bring it to me, and then we'll see what options are available to us at sentencing. All right, ma'am. So the sentencing date is
August 23rd at 8:30.
August 23rd at 8:30. So you're, is there anything else on the record in 24-00470, Mr. Stevens?
Nothing coming through, Judge, thank you.
Ms. Donnelly?
Yes, Your Honor, I'd like to discuss bond.
So you'd like a modification or a reduction of bond in this matter?
Yes, it's currently, I believe, set at $100 cash surety. I have tried to make efforts to get that money from Ms. Hill, but have failed. It's my understanding that Ms. Hill has been in talks with Bear River Rehabilitation Treatment in Petoskey. And they say that there is a bed available if she is available. So at this time, Your Honor, since she's been in custody for, I think, about 12 days at this point on this, at least, would the court consider releasing her on personal recognizance, or if a bed is available at Bear River? Thank you.
Mr. Stevens?
Yes, the only position I would take is if the court wants to modify to allow direct transport so that she can be released to Bear River versus just on the PR. And that's largely based on the fact that there is at least one failure to appear in this case, at least according to the notes that I have, there may be more. So the people certainly have some concern that a straight PR might not be the most advantageous, but at the same time, recognize the benefit of rehabilitative efforts from Ms. Hill. So going to Bear River would certainly be beneficial.
This was initially $1,000 PR personal recognizance, and then we had one fail to appear March 7th, which led to the $100 cash surety bond. I'm in agreement that I don't know if PR bond is going to hold Ms. Hill, but I will modify the bond to indicate that a direct transportation to Bear River would be appropriate if a bed's appropriate. And then I'd also okay any day for day credit. So any day for day credit, she's in Bear River. She could get. I think that's time well spent. I don't know if she's going to stay there because they had problem with the fail to appear before. So I'm going to modify for transportation to Bear River but no PR bond on the matter. And then probation will be down to see her in order to do a report. Anything else for the record, Ms. Donnelly, on 24-00470?
I have nothing else, Your Honor.
All right, we're all set. Thank you, Mr. Stevens. Thank you, everybody, for your appearance.
But if you get, but now, if you get screened for Bear River and they accept you, you can. Then you can go. Sorry.
Mr. Lowe. All right, so we're on the record in docket 24-01626. That's people of state of Michigan versus David Lowe. Will the parties please introduce themselves for the record? Mr. Stevens.
Andrew Stevens, on behalf of people.
Mr. Mills.
Hey, good morning, Your Honor. Stephen Milks on behalf of Mr. Lowe. Mr. Lowe is present, standing to my right at this time.
And sir, you are David Francis Lowe, is that correct?
Correct, sir.
Thank you. This is the time set for a preliminary examination today. Mr. Stevens, how we proceed?
Thank you, Your Honor. I guess I would say is unfortunately, we won't be running an examination on this, nor do we have any sort of resolution. Two things I'd like to place on the record. First, the complaining witness, in this case, Sarah, Hollon, who, as I understand it, has been present for previous court dates, is not present today. And the people would largely, if we were to proceed to examination and speaking with Mr. Milks, that was presumably the intention. People would likely only need the testimony from her to satisfy the first three counts. In addition to that, Officer Peter Howard, who was a subpoenaed witness, and theoretically the people could present a large chunk of the testimony through Mr. Howard from a victimless standpoint. I was notified this morning by another LPD officer that his child is very ill and he wasn't going to be able to make it today. So punchline is the people are unable to proceed today. I am not going to, as much as I'd like to, I'm not going to request an adjournment primarily because Mr. Lowe is awaiting sentencing. I believe it's in front of Judge Ward on a domestic related matter involving the same complaining witness. So once I make contact with Ms. Hollon, I intend to reissue this case, and then certainly that would hopefully clear up the matter involving Officer Howard as well. So with all of that said, I anticipate a motion from Mr. Milks, to which I have no additional response based on this record.
All right, Mr. Milks.
Thank you, Your Honor. Your Honor, as the people are unable to proceed today, we are asking for a dismissal of this matter.
All right. So I will grant the dismissal without prejudice, which means, Mr. Lowe, this case is dismissed for our purposes today without prejudice based on the unavailability of witnesses. However, you heard what I heard. So the prosecutor has indicated they do plan on reissuing this. So this is all gonna start again. We'll do the arraignment and everything. And my understanding is that one of the reasons for that is that you are facing a sentencing in another court. Is that a fair statement, Mr. Stevens?
Yes, Judge.
All right. So I'll dismiss without prejudice. Sign that. Sign the order to that effect. Thank you. There's three of them.
Yeah, there's.
All right. Thank you. Or one more. Thank you. All right, so I will sign the Nolly Cross of order dismissal for dismissal without prejudice accordingly. Let's see, one. Usually I indicate this is realistically, this is dismissed for without prejudice, and the case is dismissed today. They indicated it's going to be reissued. So you have an understanding of that, right, sir?
Sure.
All right. That's anything else for the record in 24-01626, Mr. Stevens.
No, Your Honor. I guess the only thing I would add, and I'm sure Mr. Milks has already addressed this, because there is still pending sentencing with the same complaining witness, there is still a valid, as the people understand, no contact provision in that case,
Correct.
which
I would
sort of
assume.
precipitated some of the present charges in this case. So at least from the people standpoint, talking to Mr. Lowe via the court, just because this case is dismissed doesn't mean that he's entitled to have any contact with the complaining witness, because it could just result in additional issues. Again, I'm sure Mr. Milks has already addressed that.
Right, and so that assumption is, that's the sensing in front of Judge Ward. That's got to be a DV2, I would think.
Yes.
All right.
So looking to DB4, Your Honor.
All right, so that there's continued no contact with the victim in the case. All right, with that understanding, anything else on 2401-626, Mr. Mills?
No, nothing from the
All
defense.
right, we're all set. Thank you for your appearance today.
See, there are only 3 left for the morning, one of which is Torres. So if you want, we can start.
All right, let's go on.
And I'll grab the officer to sort of speed things up, if that's okay, Judge.
What's that?
I'll grab the officer, if that's
Sure.
okay.
This is the interpreter, correct?
Yes. Deputy.
Let's make sure you have a chair next to, and then I'll swear you in once we get everybody in here.
Oh, yes, thank you.
All right, so please state your first name and last name for the record, sir.
Pablo Bello, Pablo.
Raise your right hand. You solemnly swear or affirm that you will truly, accurately, and partially interpret the matter now before the court, not divulge confidential communications, so help you God or under the penalty of perjury.
Yes, I do.
Thank you. So, sir, just let me know if I get going too fast or if anybody gets going too fast, okay? All right, so we're on the record in 24-01538. And that is people of the state of Michigan versus Enzo Perez Torres. Will the parties please introduce themselves for the record? Mr. Stevens.
Andrew Stevens on behalf of the people.
Mr. Johnson.
Good morning, may it please this honorable court. Kareem Johnson on behalf of Mr. Torres.
And sir, you are Enzo Torres, is that correct?
Torres, correcto? Yes, sir.
Thank you. This is the time set for a preliminary examination. That's my understanding. We're holding the preliminary examination. Are there any matters to come to the court's attention before we get started, Mr. Stevens?
Nothing on behalf of the people.
Mr. Johnson?
No, sir, Your Honor.
Thank you. I'll let the attorneys worry about sequestration. We'll invoke sequestration if anybody's in here and that they shouldn't be listening to another witness testify. Just let me know.
People have only subpoenaed one witness. And so I don't, from the people's standpoint, I don't think that's an issue.
Okay.
I know that Mr. Torres is here with another individual. I don't know if that other individual is or is not a witness, so I'd have to defer with Mr. Johnson.
Mr. Johnson.
Individual was not present on the day of this incident.
All right. So there's no intent to call him as a witness at this time?
No, sir, Your Honor.
Thank you.
Or in the future.
All right. With that understanding, Mr. Stevens, you may call your first witness.
People call Officer Ryan Lawrence.
All right, Officer Lawrence, I'm going to have you stand right in front of me. Please state your first name and last name and spell them both for the record.
Name is Officer Ryan Lawrence, R-Y-A-N, last name Lawrence, L-A-W-R-E-N-C-E.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Okay, have a seat. The microphone is for the court recorder, so project as best you can to the back. And we've turned off the fan so we can hear you, all right? Mr. Stevens, you may proceed.
Thank you, Your Honor. Sir, how are you employed?
I'm a police officer in the city of Lansing.
How long have you been employed in that capacity?
Approximately 9 years.
What is your current assignment?
I'm currently assigned to road patrol.
And how long have you been assigned to road patrol?
I came out of a special assignment in May to go to road patrol, but I was in road patrol from 2015 to 2021 as well.
I'm going to draw you to the specific date of May 24, 2024. On that date, were you working in a road patrol capacity?
Yes, sir.
What was your shift?
I was working day shift, which starts at 6 in the morning and ends at 4 o'clock PM.
As road patrol, how were you dressed?
I was in the uniform of the day, which is the policy LPD uniform, the one I'm wearing currently, with the badge and my name and the identifier of police on the back of my vest.
As well as, I'm looking at you in court now, a police patch on your right arm and left arm?
Yes, sir, 2 police badges.
Attached to your vest or other items as well?
Yes, sir, there's handcuffs, magazine, pepper spray. I also have a police duty belt with additional police equipment on it.
As road patrol on May 24, 2024, were you working on foot or within a vehicle?
I was in a police vehicle that was marked with Lansing Police Department insignia on both sides of it, as well as had red and blue flashing lights on the top.
On that date, May 24, 2024, did you have the occasion to be dispatched to the area of Michigan and Washington?
Yes, I did.
Is that in the city of Lansing?
Yes, sir, it is.
Hingham County, state of Michigan?
Correct, sir.
Back to a couple blocks or a block from where we currently are right now.
Correct.
Why were you dispatched to the intersection of Michigan and Washington on that date?
I was dispatched there as multiple calls came into dispatch that a man was downtown stealing items from several local businesses.
As part of the dispatch, were you provided a description of the individual?
Yes, sir. They provided the description of a white male with a gray shirt and striped brown pants.
Okay. Anything specific as to what was being taken that was noteworthy?
So the dispatch notes were slightly vague, but they said that he had stolen items from a MSU Federal Credit Union, which is right on South Washington, and a local, the Comerica Bank.
Approximately what time was this dispatch call?
This is approximately noon.
When you arrived to that location, did you observe anybody that fit the description or the information that you were provided via dispatch?
Yes, sir. I saw somebody that fit the clothing description as well as was holding items that appeared to be from a bank.
Do you recall what specific items the individual was holding?
It was bank packaging that you would put an overnight package in, as well as some stickers that are for like overnight purposes.
And how did you arrive to that area, specifically Michigan and Washington?
I drove my marked patrol vehicle.
Were you alone or were you with a partner?
I was alone.
The individual that you observed that matched the description, where was that person when you first made I'm sorry, first made visual observation?
He was in the roundabout that connects Michigan and Washington, right at the dead center of downtown.
When you say the roundabout, are you talking about the road that the vehicles travel on or something else?
He was both in the road and I couldn't tell if he was coming from the sidewalk or not because I was looking at both him and kind of civilian and foot traffic to make sure I didn't hit anyone. But I saw him walking from what could have been the sidewalk through the street where the patrol vehicle would drive, like in the roundabout driving area.
Okay. Did you make contact with this individual?
Yes, sir, I did.
Where did that contact occur?
Right on the south end of the roundabout, closer to Washington Avenue. I got as close to this gentleman as I could with my patrol car and activated my overhead lights for the police vehicle.
So you drove your vehicle directly next to the person?
I would say it was within 5 to 6 feet of him. Conservatively.
Did you make visual and verbal contact with that person at this time?
Yes, sir, from the car.
And how so?
I ordered him to stop.
Did you look directly at this person?
Yeah. And he also walked closer to my car as I was pulling up, so I knew that he had heard me.
Objection, speculation, response.
I guess part of that answer I think is appropriate. Maybe the back half of that answer, I have a tendency to agree. So I can maybe ask a follow-up question that could tighten it up a little bit better.
All right, the objection sustained factually. He indicates that he indicates what he said. We don't know if the other person heard it or not. So the objection sustained, and I'll allow you to ask more follow-up questions.
So I want to start first visually. Did you make eye contact with this person?
Yes.
This person, was that person looking or making eye contact back with you?
Yes.
So in essence, you two were face to face.
In a way, I was sitting down in a police vehicle, but the window was rolled down and we were maybe 5 to 6 feet away.
Did you then make some sort of verbal statement to the individual?
Yes.
What was that individual's response to the verbal sort of contact?
No.
Okay. Did the person remain where they were, or did they do something else?
No, sir. The person started going northbound on the kind of center area of the roundabout where like the red balls go during Christmas, that flat surface. He started walking northbound away from my patrol vehicle at that point.
All right, so if I were to call that the island of the roundabout, is that you're sort of in the same
Yes.
area?
Yes, sir.
So I'm gonna back up a second. A second ago, you said the person you made contact with moved closer to you.
Upon originally making contact, he started walking towards my car.
All right, so describe that timeline, that sequence for me, please.
I'm pulling into the area. I see a person that's matching the description from dispatch. I start pulling towards him as he starts walking towards me. My lights for my police car are activated. He's very close to me. I say, stop there. And he says no and proceeds walking northbound.
Okay. What was your next, what were your next steps after ordering this individual to stop?
I had to put my car in park kind of fast because I was afraid he was going to flee on foot. And I got out of the car and walked over to him where he had stopped about 10 to 15 feet further northbound with the intention of detaining him.
Okay. When you made contact with him, was it within this island area of the roundabout?
Correct.
Now, the person that you made contact with, would you recognize that individual if you saw him again?
Yes, sir.
You see that individual in the courtroom today?
Yes, sir.
Please point that individual out and describe the article of clothing, please.
He is in a black jacket with a gold earring in his left ear.
Your Honor, let the record reflect that Officer Lawrence has identified
Que el
Mr.
acta
Torres.
refleje que-
Any objection to the witness identifying the defendant for purposes of prelim? Mr. Johnson,
Indicando a la persona.
No, Your Honor.
No, su señoría.
without objection, the witness has identified the defendant.
Indicando
For
a la
prelim.
persona.
When you make contact with Mr.
Cuando
Torres
hizo
in the
contacto con el
island,
señor Torres.
am I to understand you are now out of your patrol vehicle?
Yes, sir, on foot.
Ya, usted estaba caminando debajo de la patrulla y empezó a caminar. Sí.
When you make contact with
Cuando hizo
Mr.
contacto con el
Torres,
señor Torres,
is it apparent to you at this time
parecía que estaba.
whether or not he understands your commands?
¿Él entendió lo que le decía?
It seemed apparent to me at the time based on him saying no to something I directly said and then doing the opposite of what I said. It seemed reasonable that he
Lo,
understood what I was saying, yes.
él entendió lo que yo le dije, porque hizo lo opuesto a lo que yo le dije que hiciera.
When you have made contact with Mr. Torres in the island section of the roundabout, how close are you to him now?
¿Qué tan cerca estaba?
I was right next to him because I put him in handcuffs. So I was physically inches away from him.
Okay.
Estaba unas cuantas pulgadas.
Immediately before putting him in
Y le
handcuffs,
puso las
what, if
esposas.
anything, did you observe him
¿Qué
holding on
¿Qué
to?
fue lo que observó?
He was holding the mail items that I mentioned from earlier that appeared to be from what I assume mail items that
Tenía
Objection.
I withdraw.
tenía objetos.
he was holding an overnight mail package and some stickers from that would go in the mail
Que iban para
for overnight or mailing purposes.
eran, creo que se manda en la noche, ¿no?
At this point, have you visually confirmed some of your initial observations upon
Las
approach?
observaciones cuando se acercó a
As
él,
regards to what he was holding,
lo que
Yeah,
estaba
Yes, sir.
sosteniendo, sí.
and that was some of the initial
Eso eran lo-
information you received that
la
dispatched you to
información
that
inicial que
location.
usted
Correct.
recibió. Correcto.
Now, with the
Ahora-
Mr. Torres in handcuffs,
Con el señor
describe what
Torres.
happened thereafter, please.
I told him that we needed to go and I had to have him sit in my police car. I didn't want to be on the island with him, knowing that it was just me and him, and he was already a flight risk, in my opinion, based on him not
Pensé que
listening to
se
me.
iba a echar a correr.
And I also wanted to move him and the police car to a safer location than in that island,
Lo quería
or
poner
in the roundabout, in the middle of downtown during lunch hour.
durante el almuerzo, ¿no?
And how did that
¿Cómo-
Go.
¿Qué pasó?
He refused to walk towards the police
No
car.
quiso caminar
And I actually
en la
had
patrulla.
to gripping his arm and using my forearm and his back, kind of move him along,
Jalarlo,
pushing
¿no?
him softly and guiding him that way. As I kind of pushed him a little bit, he did begin walking and got to the police car.
Ya empezó a caminar conmigo hacia la patrulla.
What is, if you can approximate, the
Eh,
distance
¿Cuál es la
from
distancia que había
the point where you
del
make contact and handcuff?
lugar donde
to
hizo
the
contacto
patrol
a
car?
la patrulla?
I would say about 15 feet, maybe 10 to 15 feet.
15 pies.
Once you arrive at the patrol car,
Cuando llegó
tell me what happened after
¿Qué
that.
fue lo que pasó?
I ordered him to get in the police car.
Se subió al
as
coche,
I was
a la
detaining him,
patrulla,
and for the reasons I just said, I
por la
needed
razón
to
que
secure him in an area where he couldn't try to flee on foot.
Okay.
pensé
And how
que
did
se iba a
that
echar
go,
a correr.
please?
He refused several of my orders to
No
get
quiso-
his feet in the police car. So he was cooperative when I asked him to sit in the car. And then I needed to get his feet in the car so that I could close the door,
y cerrar
and he
la
refused to
puerta.
put his feet in the car.
Él no quería poner sus pies en la patrulla, dentro de la patrulla.
And when you say
Cuando
refuse to
usted
put his
dijo
feet in the car,
que no
if you
podía poner
could
los pies-
describe that a little further for me.
¿Me
please.
puedes
So he
explicar?
was sitting facing northbound in the open back seat of the car, and he was sitting with his legs, both legs hanging out of the car, and his back
Las piernas estaban
um,
salidas de la
very,
patrulla.
very close to the end of the door, which as a result made shutting the door impossible, or I was gonna hit his legs.
No
It also
quería
made
cerrar
it so
las
he could extend
puertas,
his legs and keep the door from shutting.
Porque no quería subir los pies, no quería yo apachurrar las piernas con la puerta.
Did you give him any commands to
Y usted
move his
lo
feet
ordenó
inside of the
que
patrol
subiera
car?
I
las
gave him
piernas a la
several
patrulla.
commands to move his feet inside the patrol car, and every time he refused.
Y él no quiso.
Did Mr. Torres say
Torres
anything
dijo
verbally
verbalmente.
that indicated he was refusing?
He might have said no at the time. I do not remember completely because I was more focused on him, but additionally like nearby traffic and people and making sure they were all there.
So when you say he refused,
Cuando dijo que él no quiso,
was that more physical than verbal.
Correct.
And in what way?
He did not move his feet in the patrol car, and after asking him several times, I had to physically grab his legs and put them in the patrol car. And both, several times after that, he immediately moved his legs back out. So I physically, with my arms, lifted his legs up, put them in the car, and before I could shut the door all the way, he would straighten his legs back out so they were hanging out of the patrol car, even putting his foot on the door so that it couldn't be shut.
Did there come a point where you were joined by one or more other officers from Lansing Police Department?
Yes, sir.
Why is that?
Other officers were in the area and also dispatched to this call. I just happened to get there first. And a unrelated lieutenant was doing some other police business and happened to pull in behind my car.
Okay. At what stage of this interaction did some of those other assisting officers arrive?
After one or two failed attempts to get his feet in the car.
Did they then join you at your patrol car?
Yes, sir. Lieutenant Mills was able to grab his feet and put them in the car. And then right when he pulled his Lieutenant Mills' arms out, I was able to shut the door before he could stick his feet out.
So I'm going to back up. Now that you are joined by, you've identified Lieutenant Mills. Is it just Lieutenant Mills, or is there another officer there?
There was Officer Austin Brown also was there.
Austin Brown.
So with at least those two other officers present, describe now the interaction that you, Lieutenant Mills, and Officer Brown are having with Mr. Torres at your patrol car.
It was more of the same as to my personal interaction with them, where we were trying to physically move his feet, and every time they were in the car, they would immediately extend and flex out so the door couldn't be shut.
Did there come a point where ultimately you or Lieutenant Mills and or Officer Brown were able to successfully get Mr. Torres into the back of your patrol car and the doors closed?
Yes, sir. We had to time it like out loud where Lieutenant Mills put his feet in and I said like, all right, you ready, move. And then he pulled his arms out, and right as he was pulling his arms out, I slammed the door shut.
Okay. Was that all on one side of the car?
Yes, sir.
Did anybody assist on the other side of the car?
If they did, it would have been Officer Brown going back to pull him in. I couldn't, from my viewpoint, say whether or not he actually made contact with me.
Okay. And why is it that you and Lieutenant Mills had to coordinate this effort to shut the door as it relates to Mr. Torres?
Because every other time before we could get the door shut, his feet would come back out and stop the door from being shut.
All the way up until this successful attempt?
Correct.
If you recall, during these attempts, now yourself and Lieutenant Mills, are you giving Mr. Torres verbal instructions?
I was, and then Lieutenant Mills gave him more of the same instructions I were giving.
So the two of you are alternating?
Yes, sir.
As far as verbal instruction?
Correct.
Thank you, and I have no further questions.
Cross-examination, Mr. Johnson.
Officer, when the dispatch came in from the complaint from MSU Credit Union, the complaint from dispatch was about trespassing, correct?
I believe the complaint from MSU Federal Credit Union was originally a larceny, sir.
During the course of this investigation, did any officer go and talk to the individuals at MSU Credit Union?
Yes, sir.
And that information was shared with all officers?
Yes, sir.
People at MSU Credit Union, I believe it was the branch manager, told you Mr. Torres committed no offense in MSU Credit Union, correct?
That was not told to me. That was told to a different officer and relayed to me,
Fue a
sir.
otro oficial.
But you had that information.
Yes, sir.
Usted tenía
So
esa
he committed
información.
no crime at MSU Credit Union,
Usted no cometió crimen ahí en el.
correct?
¿Es
Well,
correcto?
I'm gonna object to hearsay.
Voy
I
a
mean,
objetar.
I let the first part in because I didn't know where it was going and arguably could have been a part of
Voy
the
a objetar
initial
esto
dispatch.
porque
Now that we're
fue-
getting into
está
sort of a
mandando
substantive question, then I'm gonna object to hearsay.
Here's why it's not hearsay, because it goes to the effect on the listener and why this
esto-
officer took those.
So I'll accept it, but not as substance, as something
Well-
other than the truth.
And then I'll move to strike that question because the question was, isn't it true he committed no crime based on the statement from MSU? That is essentially a substantive, asking for a substantive answer.
que está pidiendo una-
Response.
su respuesta.
That's fine. I'll
All right.
rephrase the question.
Objection sustained.
You had no information that he committed a crime at
No había
MSUFC.
cometido ningún crimen.
I would think it'd be more fair to say that there was no victim there to prosecute the crime. There was information that maybe he had taken something and what he had taken, the person did not stick around.
You don't know
Pero que usted
what
no
he took from
sabe
that person was actually his.
si
Correct.
era él, ¿no?
Now,
Ahora,
you pull your squad car up
usted llega con su patrulla.
and Mr. Torres
y el
is
señor
walking
Torres está caminando
in the opposite direction, correct?
en la dirección
He was
opuesta.
more walking, you talking about upon initially seeing him,
Yes.
sir?
Cuando lo-
He was kind of walking northwest. I would say it would be more towards my police car than away from me.
hacia mi
You had your
patrulla.
window down.
Yes, sir.
Tiene la ventanilla bajada. Sí.
You were wearing a body camera.
Yes, sir.
Una
Is it your
cámara.
testimony
Es su testimonio
that your first words to him
que
when you were seated in your police car,
usted estaba
was
en su
stop?
patrulla.
or was it, hey, can I talk to you?
Hey, ¿puedo hablar con
My
usted?
first words?
Yes.
Mi primer-
I would believe it was, hey, can I talk to you? If
Hey,
that's what you're
¿puedo
saying.
puedo
sir.
hablar contigo?
Well, I'm at, if you don't remember, then
Si
that's
no
fair.
recuerda,
But
está bien.
Was your first words to him
Primer
something to the
pregunta,
effect of, hey, can I talk to you?
¿puedo hablar
I do
contigo?
not remember timeline of words.
No me
Okay.
acuerdo, no me acuerdo.
He says
Él dijo que.
something to you, but then he says no. And walks away.
Y se
Correct?
camina.
Correct.
Correcto.
You then get out of your car,
Te bajas de su patrulla,
walk after him,
te acercas a él.
correct?
Yes, sir.
You tell him stop.
le
Yes,
dices
sir.
que se detenga.
When you tell him stop,
Le dijiste que se detuviera.
So let's make sure. I'm gonna have the interpreter, I'm gonna move the mic towards Mr. Johnson so we can hear Mr. Johnson's questions.
Para que
Because we're hearing more of the interpreter and less of Mr. Johnson. So, all right, with that understanding, you may proceed.
when you told him stop, he stopped.
Pare.
Outside the car, sir?
Yes.
Correct,
You then went to go put handcuffs on him.
Y
correct.
le ponen las-
You didn't tell him he was under arrest,
At the time, he was not under arrest.
but you were putting handcuffs on him.
Pero
Yes,
le
sir.
pone a-
You didn't tell him that he was detained.
Usted nunca le dijo que estaba detenido.
I don't remember if I did tell him I was detaining him or not, sir.
No recuerdo. Si le dije que
And
estaba
so you agree there was no probable cause to arrest him at the moment you put handcuffs on him.
que estaba detenido. No había-
There was no probable cause to make an arrest at the time, sir.
había causa probable
Now.
para hacer un arresto.
The items that you saw were inside of a UPS bag, correct?
Estaban bien,
Yes.
estaban adentro de una bolsa de UPS, ¿correcto?
So you didn't see those items when you first saw Mr. Torres, you just saw the UPS bag.
UPS,
Entonces,
sir.
la bolsa de
You went
UPS,
inside the UPS bag and saw the
bolsa de
items.
UPS,
Yes.
perfecto.
You did not have a warrant to go inside the UPS bag,
Usted no tenía
correct?
Correct,
You didn't have Mr.
Permiso
Torres's
para-
permission to go inside the UPS
para
bag.
revisar la bolsa,
Correct.
¿correcto?
The items inside the UPS bag
Yeah.
were not from
No
MSU
era
FCU, correct?
de-
Correct.
de la-
The
del
UPS
banco,
bag, you were unable to ascertain who that
de-
bag belonged to.
No sabía de quién
Correct.
era la bolsa, ¿correcto?
throughout my investigation,
Yeah.
no, I figured out where it came from, sir.
Came from Mr. Torres,
Vino
I'm
del
sorry,
señor
what?
came from Mr. Torres.
Vino del señor Torres.
Originally, but there's camera footage of where he got that item.
¿De dónde
We'll talk
sacó?
about, that camera footage was from a young lady, correct?
Yes.
De una
She
señora.
walks, okay, what was it, what she said? But in that camera footage,
En la-
are you sure that Mr. Torres didn't already have
ya
that
tenía
UPS bag before he went to the
esa
drop box?
bolsa antes de que
Camera
fue-
footage shows from that angle, it doesn't look like anything but a normal bag was in his hands that was in
Una
his property.
bolsa.
And then he reaches into the top of the brown box. There's a better word for it, sir. I'm sorry, I don't know, the UPS box.
We'll call it UPS box.
Okay, and then he has those items now in his hand as he's walking away.
Y tiene sus objetos que
The
está
UPS
caminando.
bag
Y la bolsa
had no mailing address,
no tiene
Correct.
dirección,
Correct,
had no return address,
no tiene dirección para regresar,
correct?
correct,
Was not sealed,
no está sellada, correcto,
had no postage on it.
correct.
y no tiene tampoco el sello postal, correcto.
At this location you were at,
Y este lugar que usted
there
llega,
are several places where you can seat a subject.
puede ver un sujeto,
See
¿no?
the subject, sir?
Have somebody sit down.
Sí, hay
Yes.
ahí.
Okay. So there were other places to sit down other than the squad car.
Además
Yes.
de la
Now let's
patrulla.
talk, because you said
Usted
you
dice,
walked him back to your squad car.
Yes,
usted lo
Are you
lleva
sure?
a su
Yes.
patrulla, sí.
Other officers arrived, specifically one in an Explorer.
Y
Correct.
quieren explorar, ¿verdad?
Mr. Torres wasn't walked to the Explorer.
I was in an Explorer.
No caminó
You were
hacia
in
la
Explorer.
patrulla, el Explorer,
After you
y
get him into the Explorer,
lo mete a la
you and two
patrulla.
other officers are talking about the investigation, correct?
Los oficiales y usted
Yes,
hablan de la-
The statement is made that you have nothing on Mr.
No
Torres.
tiene
Objection,
nada
hearsay.
en el señor Torres.
Yeah, the statement came from him.
That's
Still hearsay, but
Not if he-
response.
Okay,
He's not an opposing party statement.
Ah,
That's what I think that's the theory that you're going under.
está
No,
llegando, ¿no?
he made the statement,
Él hizo la
Correct.
declaración.
right?
Right.
So he's the
And
declarant
a
available.
hearsay is an out of court statement offered for the truth of the matter asserted, right? And so it doesn't say anything about whether it's just out of court. It doesn't matter that if he's on the stand,
Made by someone other than the declarant. The declarant is here to be cross-examined.
made by someone other than it's an out of court statement offered for the truth of the matter asserted. Okay, he's here. He can say, you can ask him, did you say this? He can say yes or no. But that's the amount of it.
Did you say at that time that there was nothing, that you had nothing on Mr. Torres?
I don't recall saying that, sir.
Okay. At that time, did you have an arrestable offense for Mr. Torres,
Yes, sir.
other than the obstruction?
No, sir.
Okay, so the arrestable offense was the obstruction.
La obstrucción, ¿no? Solamente.
Can I ask you a clarifying question to make sure I'm understanding? this?
Yes, sir.
You're saying at the time, are you talking about immediately when he's in the car or after the investigation? After the investigation was complete, talking to the other people?
When you first put him in the car,
Okay.
what was the arrestable offense?
Once he was in the car, there was no arrestable offense besides the obstructing that you mentioned, sir.
Okay. When you detained him,
Cuando lo detiene,
this is before you had begun any investigation.
hay una
Yes,
correct.
investigación
You had no information at the time you put him in handcuffs that he committed an arrestable offense. Did you?
para arrestar.
I didn't, because I didn't have time to investigate, sir.
No tenía tiempo
No
de
further
investigar.
questions.
No tengo más
Thank you.
preguntas.
I need redirect Mr. Stevens.
Sin redirigir, señor Steven.
No,
No.
thank you.
May this witness be excused from the people,
Without objection.
from the defense.
No objection, Your
All
Honor.
right, thank you. Thank you for your appearance today.
Gracias, señor. Gracias.
Any further witnesses from the people, Mr. Stevens?
No, Your Honor, thank you.
Any witnesses, do the people rest?
Yes, Judge.
Any witnesses from the defense of Mr. Johnson?
No, Your Honor.
All right, thank you. Motion for bind over, Mr. Stevens.
Thank you, Your Honor. People move to bind over as charged. Testimony from Officer Lawrence is that he was working as patrol officer on the date specific of May 24, 2024. Marked police vehicle in the standard uniform that he verbally described, but also indicated that he was wearing today, that this court was able to see, that he was dispatched to
Y lo mandaron
the
a
specific intersection of Michigan and Washington, which is in the jurisdiction and venue of this court,
jurisdicción de este tribunal,
that he made contact with Mr. Torres, that he identified here in court,
identificado aquí en el tribunal,
and that he was specifically dispatched to that location to investigate a series of calls
varias llamadas
ranging or centering around potential larceny,
relacionadas con un robo.
that he, upon approach, observed an individual, specifically Mr. Torres, that matched that description,
Tenía esa
with
descripción
items in his hand that was consistent with the initial dispatch.
manos,
And in the course of trying to investigate that,
estaban tratando de investigar eso,
spoke to
hablé
and then further
con
ordered Mr.
el
Torres
señor Torres
to stop so he could continue his investigation.
para continuar con la investigación.
Officer Lawrence then testified that
Oficial Lorenz dijo que el
Mr. Torres
señor Torres
verbally said no,
verbalmente dijo no,
turned in the opposite direction from Officer
caminó
Lawrence and
hacia la
began walking
dirección
away.
opuesta,
which at that point prompted Officer Lawrence to park his vehicle, his patrol vehicle in the roundabout,
En la glorieta,
leave his vehicle unattended,
dejó su
to
vehículo
then make contact with Mr.
desatendido para hacer
Torres.
contacto con el señor Torres.
From that point,
En ese momento,
in order to continue that investigation, Officer
el oficial
Lawrence detained Mr. Torres,
detuvo al señor
giving
Torres
him further instructions
para
to
darle
move towards the patrol vehicle, which was met with some reluctance.
donde se resistió,
In an effort to move Mr. Torres away from the center of this roundabout area and also to move this patrol vehicle. Officer Lawrence guided Mr. Torres to the back of the patrol car and ordered Mr. Torres to place his legs in the vehicle so that they could move. That was also met with additional resistance, resulting in at least two officers, Officer Lawrence and Lieutenant Mills, having to physically put Mr. Torres in the back seat so that the door could be shut, and then Officer Lawrence could continue with the investigation. Consequently, it is the people's position that based on that record evidence, necessary elements of count one have been met to a probable cause standard and would ask for binding arrest charge. Thank you, Judge.
Thank you, Mr. Stevens. Response, Mr. Johnson.
Yes, Your Honor.
Sí, su
It's
señoría.
the defense position that People v. Moreno controls what happened on the street that day. Officers get a call.
Los oficiales los llaman.
Let's assume the call
Vamos a asumir que la llamada
rises to the level of reasonable suspicion that criminal activity is afoot.
hay una actividad criminal.
The officer responds.
El oficial responde.
That officer
Ese
chooses
oficial
to stop his car in the middle of the road.
pararse en
Rolls down his
la calle.
window. Think based on cross-examination, he's unsure at that time.
No sabe,
He
no
says,
está
hey, I
seguro.
want to talk to you,
Quiero hablar contigo,
or stop.
o que te pares, ¿no?
He indicates that Mr. Torres says something, says no,
le dice
walks
no,
away.
y camina, y se camina.
Our position that was a consensual encounter.
Eso fue un
He doesn't
encuentro
indicate to Mr. Torres that
consensual.
he's being detained.
Está
He doesn't
detenido,
indicate to Mr. Torres he's under arrest.
y le indica
Then that
que el
officer
señor
chooses to get out of the
está
car,
para frente,
leaving the car where it is.
deja
to proceed
la
after Mr.
patrulla donde
Torres.
está para
Now,
perseguir.
it is undisputed
Es
that at
indiscutible
this time,
que en este momento
he tells Mr. Torres,
el
stop,
señor Torres
and Mr. Torres stops.
el señor Torres se
So
detiene.
he's not a flight risk.
Tampoco se
When the
escapa, ¿no?
magic words are uttered by a police officer,
Las-
stop,
párate,
he stops.
y se para, ¿no?
Now, if the court believes
Pero si el
he
juez
had reasonable
que
suspicion,
tenía una
that is the
sospecha,
scope in which the officer is allowed to do.
está permitido por
Mr.
los oficiales,
Torres,
eso. El
There's
señor
no reason to
Torres
believe is armed or dangerous,
no está armado, no está
hasn't physically
peligroso,
resisted,
tampoco se
and has now
resiste,
complied with officers.
no sigue la instrucción del
But
oficial,
yet he is now handcuffed,
pero le ponen las
which
esposas,
elevates
lo que eleva,
the nature of the seizure. Then now, against his will, he is walked to a police car, which further elevates the nature of the seizure. And now they're trying to lock him in the back of the police car, which is now a full-blown custodial arrest. An unlawful one that its defense position was unlawful. And he had a common law right to resist,
Es ilegal, ¿no? Lo que es.
coupled by the fact that at this time,
Entonces, en este momento,
other officers have arrived.
otros oficiales llegan
There was nothing preventing the officer
para aprender a los
from having Mr. Torres sit
que se
at
sentaran
some location on the roundabout
en
or one of the many benches over there,
alguna de
which
las
police have people do all the time, sit on the
lo que
curb
hacen
or up
los
against a wall,
oficiales que
and
se sientan,
investigate.
investigar, ¿no?
Had they investigated,
Investigar,
they would have
si
determined
hubieran investigado, hubieran determinado,
there was no probable cause to arrest Mr.
no
Torres for
había ninguna
anything.
causa para arrestar al señor Torres.
Police jumped the gun,
La policía salta la pistola,
went hands-on an individual
le pone las esposas al individuo,
unlawfully,
sin
and I
ilegalmente,
believe created a situation
y crean una situación
where they had to charge obstructing
donde tienen que
to
hacer cargo de
avoid this
obstrucción
unlawful, claims of unlawful detention.
de esta
unlawful arrest.
detención ilegal.
Mr. Torres did nothing wrong that
No
day,
hizo nada ese día.
and I'd ask the court to hold
Pido al tribunal
that placing handcuffs on him
le ponen las esposas,
was far beyond the scope
fue más allá de la
of the
investigación,
suspicion the officer had available to him
la
at that
sospecha que tenía el
time.
oficial en ese momento,
Take him to the police car and
le
attempt
llevan
to
a
lock him in the police
para
car
meterlo a la patrulla.
clearly exceeded the scope of any lawful
Y
seizure.
eso se
And that
pasa
people
de-
v. Moreno gave him the right to resist.
y tampoco le
Thank
dan
you.
la-
Any response, Mr. Stevens?
Just 2
Respuesta, señor
points,
Steven, 2 puntos
and they're sort of connected.
y están conectados.
First,
Primero,
the fact that
el hecho
both
de que
parties
ambas partes
can essentially argue the facts in a different direction
discutiendo
lead to one ultimate conclusion, that there is an issue of fact
hay-
that is to be determined by the trier of fact. The tie-in here,
Entonces hay que unir
even
esto.
if the people were to concede the
Si la
argument
gente
that
considera
Mr.
que el
Johnson
señor-
is making, he cites
señor
to
Johnson
Moreno.
es
Moreno is controlling.
Moreno es controlar.
The important part about Moreno, though,
La
is it
cosa
says
importante
any
de Moreno
issue
es que
as it
cualquier
relates
problema
to the lawfulness
que
of an
se
arrest
relaciona
and
con la-
or
la legalidad del
resisting an
arresto,
unlawful arrest
resistirse a un
must
arresto
be determined by the trier of fact,
de-
which is the jury. So even by Mr. Johnson's own argument, he's essentially saying this case needs to be bound over
tiene que
because
ser
he's citing to Moreno,
porque
which says the
está
jury
diciendo-
needs to
está
decide this.
citando a Moreno.
So I recognize the facts and the arguments that Mr. Johnson makes, but he only establishes further and further establishes and supports the argument that people made, which is this matter should be bound over.
Thank you.
Caso de ser-
All right, so the court's had the opportunity to hear witness Officer Lawrence testify in regards to the bind over request for resisting and obstructing. The probable cause has been met as to date, which is May 24th, 2024. Location and venue, which is Michigan, Washington, City of Lansing, Ingham County. Identification was made through Officer Lawrence, who testified that this was the individual who he had an encounter with. So we go to the elements of the crime. The standard for preliminary examination is probable cause, which is the second lowest standard in criminal law. The lowest standard being surprisingly and specific to this reasonable suspicion out of Terry. Reasonable suspicion is to criminal activity, is to articulate criminal activities afoot, and investigation is to follow as to whether whether there's an appropriate detainment or not. It appears to the court based on probable cause level that Officer Lawrence was investigating the initial report from dispatch. The defendant was in the same clothes that dispatch had indicated to him when he initially approached, and this is where credibility becomes an issue under Moreno and under the bind over for the trier fact, who's a jury. This, of course, is a preliminary examination. That Officer Lawrence indicated that in a full marked car, in a full marked uniform, he addressed Mr. Torres to stop. Mr. Torres did not stop, and then the investigation goes from there into what is a test of wills, so to speak, concerning whether Mr. Torres is going to be detained, and then later whether he's going to stay in the car that he's been placed in. I find so credibility is an issue. This will be bound over to circuit court on that credibility issue. I find that the elements are met at a probable cause level, that the police officer had reason to know or was performing his or her duties in the investigation of the crime in downtown Lansing at noon, from reports made by Michigan State University, and that the defendant did assault, batter, wound, resist, obstruct, oppose, or endanger the officer as he was trying to perform his lawful duties. I found that this has been bound over at a probable cause level. Bind over is charged at a probable cause level, and I will indicate that for the record. The examination was held on today's date, June 21st. And based on the testimony of the witness, the prosecutors met their burden of probable cause for location, offense, venue, ID, and date. So This case is done in district court.
Este caso se acaba aquí en la Corte del
It's
Distrito
been bound over to circuit court where the trial is going to be held.
y se manda al otro tribunal donde se va a llevar a cabo un juicio.
And you'll get your next date from the defense attorney, Mr. Johnson.
Le vamos a dar, el abogado Johnson le va a dar la fecha de la próxima
That'll be at the circuit court building.
y eso va a ser en la Corte del Distrito.
Anything to come to the court's attention before the court signs the bind over Mr. Stevens?
Nothing for the people, Judge. Thank you.
Mr. Johnson.
No, Your Honor, thank you.
All right, thank you. Your time in district court is done. You'll be bound over to circuit court as you are now, and you'll get your next date from Mr. Johnson, all right? Thank you for your assistance.
Thank you, Your
today.
For up to today.
That's important.
Like, yeah, like don't charge them.
Yeah, that's sort of.
Jackson's represented by Paul.
Fair, so right.
I did not verbalize it. That was sort of what
So-
we were getting into.
What about the other thing?
I gotta let me look at this.
Mr. Stevens, you probably need a break,
I'm
just to
I have
see where
two-
everybody.
Yeah, I have two. I'm working on one with Mr. Palmer and I gotta reconvene with Ms. Wanji.
All right,
So, I mean, that was a long-winded way of saying yes.
Just let me
but I
know.
don't think it should be very long.
all right, just let me know. We'll take a break.
All right.
The only thing that I'm worried about is. Now,
Yeah, I'm gonna grab a quick.
my concern would be.
That's not a bad idea.
No, grab a-
Right, so we're on the record in at docket 24011628. That is people of the state of Michigan versus Jeremiah Jackson. Will the parties please introduce themselves for the record? Mr. Stevens,
Andrew Stevens on behalf of the people.
Mr. Palmer.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Jeremiah Jackson, who is the gentleman standing to my right.
Sir, you are Jeremiah Jackson, is that correct?
Yes, I am.
Thank you. This is the time set for a preliminary examination today. Mr. Stevens, how are we proceeding?
Your Honor, it's my understanding that parties have come to an agreement on this matter, specifically that Mr. Jackson would be pleading to an amended count 1, domestic violence second offense notice. That's 750813. 1 year and or $1,000 fine. Additionally, pursuant to the court rule, the parties have agreed that the defendant, have agreed to a sentence agreement of no upfront jail.
The Killebrew agreement of no upfront jail. Is that a fair statement, Mr. Palmer?
It is a fair statement, Your Honor. I guess the one other part I will address is that my understanding, and I don't think Mr. Stevens or I have any specific proof of this, there was some allegations made by the complaining witness about potential contact by Mr. Jackson. The parties are agreeing that that the people will not pursue any charges related to those alleged contacts up and through today's date. Of course, to be clear for the record, I have advised Mr. Jackson that should he have contact with the complaining witness at some point after today's hearing or at some point in the future, that is on him, and Mr. Jackson understands that that may result in a bond violation and or additional charges.
Thank you. Is that a fair statement, Mr. Stevens?
Yes, and or it could result in this court not having to follow the sentence agreement as well. Under the court rule, any misconduct, which could include bond violations, means that this no upfront agreement the court doesn't have to abide by and also doesn't have to allow the defendant, Mr. Jackson, to allow him to withdraw his plea.
Absolutely correct, Judge. I agree with that. Mr. Jackson and I did talk about that. He understands that if he violates the terms of his bond conditions between now and the sentencing date, whenever that may be, that the court would no longer be bound by the Killebrew agreement of no upfront jail, but Mr. Jackson would lose his right to withdraw his plea. So he's certainly aware and advised of his responsibilities, and I have no doubt that Mr. Jackson will follow those.
All right, so those are part. So Mr. Jackson, just so there's no ambiguity here, this is a plea to count 2 of domestic violence in the second degree pursuant to 750.81 parents 3. It's a 1 year and or $1,000. There's a Killebrew agreement, a no upfront jail at this time. There's also an agreement that any potential contact charges that may be investigated and pursued through today's date will not be pursued, and a violation of that would affect the Killebrew agreement. Do you understand that, sir?
Yes, Your Honor.
All right. Make sure to put through today's date. And is that a fair statement, Mr. Stevens?
It is, Your Honor.
All right, thank you. So I'm in possession of an advice of rights. So the guilty plea would be to the domestic violence second, that would be the prior, would be to aggregate it.
Yes.
Yes.
Okay, all right. And I'm in possession of advice of rights. This is signed by yourself at the bottom of this page, indicates you understand the 12 rights. Is that correct?
Yes.
All right. I'll go over your rights just to make sure you understand that there's a Killebrew agreement and no upfront jail between the lawyers. If I was not to follow that Killebrew agreement at sentencing, you'd have the opportunity to withdraw your plea. Do you understand that, sir?
Yes, sure.
Okay. You have the right to be tried by a jury, to be presumed innocent or proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question any witnesses that are brought against you. You are, of course, represented by attorney Robert Palmer today, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, sure.
You have the right to have the court order witnesses to appear in your defense, remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. I've just gone over the rights that you signed in your advice of rights. Do you have any questions concerning those, sir?
No, sir.
If you're please accepted, you'll give up the claim that the plea was a result of any promises other than what's been stated on the record. or threats that it was not your choice to plead guilty. You'll also be giving up the right to appeal anything from a trial. Since you won't be having a trial today, you'll be pleading guilty instead. Is it your wish and intent today to plead guilty to the domestic violence second?
Yes, sir.
All right. You have you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right. I'm going to bring your attention back to June 1st, 2024 at the offense location of 5510 K North Road, Apartment 7, City of Lansing, Ingham County. Were you at the 5510 K North Road address in the City of Lansing in Ingham County on June 1st, 2024?
Yes, sir.
Right. And you're pleading guilty to domestic violence. So I want you, so you're going to plead to the offensive touching of another that was not done in self-defense. All right, sir? Who is Andrea Martin to you?
Was a girlfriend at the time.
Okay, so you were dating her at the time. All right. And what makes you guilty of the domestic violence counts on that date and time that was an offensive touching to Miss Martin that was not done in self-defense?
Judge, if I might assist.
Absolutely.
Mr. Jackson, I'm going to take you back. On June 1st, 2024, you were at 5510 K North Road. Is that right?
Yeah.
And that's apartment 7. That's your apartment.
Yes.
And at the time, there was a person by the name of Andrea Martin there.
Yes.
And at least, I know not anymore, but back at that time, June 1st, she was your girlfriend. Is that right?
Yes.
And while you guys were there, you got into some sort of an argument. Is that right?
Yes.
And that argument became physical.
Yes.
And during the course of that argument, once it became physical, did you do something that would be harmful or offensive to her? That is, did you shove her, punch her, slap her, kick her, pull her hair, something of that nature?
Yes.
And what is it that you did?
Just pushing her off me in her back and stuff like that.
You pushed her in her back?
No, pushing her off of me.
Okay. So, all right. So you shoved her.
Yes.
And you agree that you were not acting in self-defense at that time. Is that right?
No. What?
Okay, hold on just a second, Judge.
Do you want some time with?
Yeah, could I just step in the hallway just very briefly?
And Miss One, she's on Miss Hats. Is that correct?
Yes.
Thank you, Judge. We're ready to proceed.
All right, so we're back on the record in 24-01628. Mr. Palmer, you had the opportunity to speak with your client and you can continue the factual basis for the plea.
Yes. Mr. Jackson, just to remind you, we're talking still about June 1st, 2024 at 5510 K North Road, Apartment 7. You have indicated that you were present on that date and at that location with Andrea Martin, and you said that you shoved her. Is that right?
Yes.
And you were not acting in self-defense, correct?
No.
Is that correct?
Correct,
That's correct?
correct.
All right. So you had no legal justification to shove her at that time.
Correct.
And you would agree that she may have interpreted being shoved, she may have felt that being shoved was harmful or offensive.
Yeah.
I believe that satisfies the facts. I'm sorry, actually. And Mr. Jackson, you had at least once previously, I believe in 2018, been convicted of the offense of domestic violence, first offense, which was a misdemeanor. Is that right?
Yes.
And that makes this your second conviction for that, correct?
Yes.
That satisfies the factual basis, I believe, Judge.
Any questions concerning the factual basis, Mr. Stevens?
No, the only thing, and I will certainly defer to the court, as to the prior, I can go into more specifics or I can ask more specifics. I don't know that that necessarily is required, but I'll leave it to the court's discretion.
I have the prior conviction of 2018. There's also a prior conviction of 2019. Is that correct?
Yes, and it was, both were here in the 54A District Court. I think that's generally all that is
Right.
needed.
I think that's all that's needed.
Beyond that, I have no additional questions.
All right. With that understanding and Mr. Palmer's questioning, I find the factual basis to be knowing, voluntarily, and accurately made. We're going to refer this to probation, and what they're going to do is they're going to develop a report for me, and And then we'll come back and see what options are available to us at sentencing, all right? So you should go down to the 5th floor after this, find out who the probation officer is, and then find out what date, if it's not today, what date they'll assign for a report to be done, and be as candid as possible with them, all right? All right, we'll set for sentencing,
August 23rd.
August 23rd at 9 o'clock. There's a continued no contact with this Martin as a part of this. Mr. Jackson should still be on GPS tether, is that correct?
He is on GPS
Okay.
tether, Judge. I was actually going to address that, but certainly, yes, he is
All right.
actually is on GPS.
All right, so anything come to court to come to the court's attention, Mr. Stevens,
Nothing from the people.
Mr. Palmer.
Your Honor, two things, I guess. One, I just wanted to make clear, Mr. Jackson resides at the 5510 K North Road, Apartment 7. That's the address that was provided to both pretrial services and on his advice of rights form. My understanding is he intends to return there. The complaining witness, or now victim, I suppose, does not reside there. So I'm just making the court aware of that. That one issue. Obviously, Mr. Jackson has been wearing a GPS tether. My understanding is he's been residing at that, and the GPS tether has not been going off by any means. So I just wanted to make the court aware of his location. The other thing, obviously, Your Honor, I certainly understand if the court wants to defer this until the sentencing date, but I would point out that Mr. Jackson was wearing a GPS tether, which of course is a standard condition of a felony offense. Now that Mr. Jackson has entered a plea to the reduced charge of misdemeanor, I would ask that the court consider removing the GPS tether. But again, as I say, if the court wants to defer that until the sentencing, I also understand we can raise it again at that time.
All right, thank you, Mr. Stevens.
I would, on behalf of the people, would like to take the approach that Mr. Palmer suggested, sort of on the back half, which is request that court defer this issue at least until the time of sentencing. The people acknowledge that there, at least to our knowledge, that there is not any zone restrictions. However, I don't think we can ignore the fact that as part of the plea agreement, there is at least built in there the suggestion, whether factually supported or not, that there may have been some improper phone calls leading up to today's date. And so I think leaving the tether in place is just another incentive to keep that distance, but also to ensure, frankly, from Mr. Jackson's standpoint, that he can have that no upfront jail agreement that the parties were able to negotiate and demonstrate to this court that he's worthy of that. So from that perspective, the people think that deferring at least to the time of sentencing, which is just under 2 months or about 2 months, it seems appropriate.
Right, thank you. So I'm not going to modify the bond at this point in time. We can revisit it at sentencing. I think this is there are some priors here that probation is going to want to look at. Also, Mr. Jackson, the GPS is there for your protection also. It keeps track of you and it indicates where you are and where you're not. And so if there's allegations made and then we're able to see where you are and where you're not, that only acts as a protection of you concerning the no contact order. So I know physically it can be uncomfortable and kind of a pain, but it's there to protect you and to protect the fact that you continue on the no contact order. Okay. And part of the plea agreement was that there would not be any continuation. Ms. Martin will be requested and reviewed for the probation report. I don't know what she'll say or what she's going to say, but I think this is a good idea just to leave this until sentencing for all parties involved. Anything else? So that sentencing will be August 23rd at 9 a.m. Anything else for the record in 2401628, Mr. Stevens?
Nothing from the people, Judge.
Mr. Palmer.
I have nothing further, Your Honor. Thank you.
You're all set, Mr. Jackson. Thank you.
All right, so we need to stay right there. All
are we ready to go on Ms. Hats?
Yes, Judge.
All right, so we're on the record in docket 24-00908. That is People of the State of Michigan versus Emma Hatz. Will the parties please introduce themselves for the record? Mr. Stevens.
Andrew Stevens, on behalf of the people.
Ms. Swanton.
Assistant Public Defender, Melanie, everyone, for me starts by my side.
All right, and ma'am, you are Emma Hatz?
Yes, Your Honor.
Thank you. This time set for a preliminary examination today. Mr. Stevens, how we proceed?
Thank you, Your Honor. Unfortunately, we have not resolved this matter, and at this point, in today's date, people are unable to proceed. We largely, from the people's standpoint, largely intended on calling the officer who investigated this, Officer Bailey Uberoth. It's at least my opinion on behalf of people that that officer's testimony would have satisfied the necessary elements for count one. As a result, I anticipate Ms. Wanji will be bringing a motion. I would just advise, similar to what I have on another case this morning, I intend to have this case reauthorized. Additionally, Ms. Hatz also, Ms. Wanji knows this, also has another case that will likely be charged. That resulted, as I understand it, from one of Ms. Hatz's presence here in court. And so within a short time period, she'll likely have 2 open felony warrants. Frankly, I know Ms. Wanji is doing what is best, and she's ethically bound to do the best on behalf of her client. From the people's perspective, we have significant concerns about Ms. Hatz being out in the public, given drug history and that have occurred prior to today's date. But consequently, if this case is dismissed, the people have, and this court has no jurisdiction or ability to control that. So I'd like to ask for an adjournment, but I don't have any facts that necessarily I could present to this court from my ethical standpoint to do so. So with that, I will defer to Ms. Wanji.
Ms. Wanji.
Then I would ask for this, so we're ready for the preliminary exam, and we have already adjourned and waived our 21 days, but today we're gonna be asking for this.
All right, this does stem from a fail to appear from April 11th, and then 1, 2, 3 adjournments that were continued for negotiations. It was waived on April 26, 2024. I understand the nature of this case, and so this case is going to be dismissed without prejudice at the request of counsel. Understanding that I usually say that it's dismissed without prejudice, and that means for all intents purposes, that realistically the case is dismissed. They're going to reissue this. Okay, they're going to reissue this. They're also going to reissue. They're going to issue the other case. All right, it's my understanding. So you're going to go through the process again. All right. That's what I'm telling you. That's the plan right now. May not happen. I don't know, but that's the plan right now, is to get you through the process again. So the case is dismissed without prejudice at the request of opposing counsel. And Ms. Wanji, I don't know if that's printed or okay. Ms. Wanji, do you want to grab that for me off the printer? There we go. You may. Thank you, Ms. Wanji. I'm in possession of the order of acquittal for Nolly Pross concerning this matter. And I will sign it in regards to this file. Understand it's dismissed without prejudice, so they could reissue if they choose to. It's my understanding you've heard what I did, that it may be reissued, but the case is dismissed for our purposes today. All right, ma'am? All right.
Will you send me something in the mail if they choose to reissue it?
I think you'll get probably notice sent to the last known address. You'll probably get it from the court if the warrant's issued. And our last known address for you is Kalamazoo.
I'm about to change that.
Do you want to update that?
Yeah.
Let's go ahead and update that address then. I have a Holt, Michigan address.
That's the one.
Okay, is that what's in the computer? 1792 Hall Street. Let's put that down because I think that's a better notification address. What's that? I don't know if we'll go, there's two out there. Yeah. But let's update the address anyway.
What's the address?
1792 Hall Street, Holt, Michigan, 48842. And you might want to check with the court to see if there's a warrant for you, okay? Within probably the next 2 weeks. Yeah, I would check.
And then if I just come in here.
You can call into the criminal clerk's office and they'll tell you, and then you can come in and get arraigned on it. All right. That's probably the safest thing to do because I don't know if you'll get notification from the court, but definitely the warrant will be in the system if it's been reissued. Right. All right. You're all set today. Thank you for your appearance, Ms. Hatz.
Thank you, Your Honor.
Should be, right?
Mr. Stevens. So you get to cover and be unit chief today.
I guess.
Pretty happy about it.
Yeah, doesn't he? Does he seem really happy about it?
Thrilled, super happy.
Yep. I worry more about Miss Hatz's own personal. So she came in here one time and we remanded her. She looked awful. She looks like 100% better, but she was, it was scary.
What should I do about my tether?
We'll contact the tether agency and they'll remove it on this file. If that's the only file it's there for, so contact them. It's a private agency.
Okay.
Okay.
Thank you.
You're welcome.
Yeah, you gotta go to the JSG in Mason. It's right there next to the jail. It's the building that used to be the old Pizza Hut. It still looks like a Pizza Hut. It has like the goofy roof on it. It's that spot. That's where you go.
And then we'll email them to let them know that it's been removed.
Okay, thank you.
That's offensive. That roof line is iconic.
I know.
Call it.
I love the pizza Hut. Remember when they used to have the pizza buffet?
Ah, dude, it was the greatest.
There's no Pizza Huts anymore.
I don't
They're
think
all
there is.
gone.
I think
They're all up north, I think. I think they're all up
There's
north.
two around here. There's one in Grand Ledge and East Lansing. I think the one in Grand Ledge you can still sit down in and eat. The one in
Really?
East Lansing, it's just basically carry out only. Well, it is carry out only for delivery. So yeah, the one in Grand Ledge, it's right in front of the Grand Ledge Meyer.
Okay.
There's one in Grayling. There's one in Gaylord. There's one. It's as if they just left.
Yeah.
They left all at once. So,
There's one in Albion, but they closed out the buffet, they got sheets over it, like.
I
Go in there, it's all covered up, like, okay.
Buffet was the greatest, man. Lunch
Is the
buffet.
roof gonna be open for a minute?
Yeah.
I'm just wondering if I could leave my bag here for a second while I go tell Chapman this case.
Sure.
Yeah.
We charge a fee now, Mr. Palmer.
Okay, can you bill it to my office?
Sure.
And then we have Mr. Risper this afternoon.
Yeah.
All right. And did Mr. White file an appearance on that?
He did.
I don't know. I can look into that beforehand.
He did file. So Mr. White filed an appearance on that.
I don't want to say too much, but I don't want to run afoul to ex parte.
Well, yeah, I know. I just heard today that he may have made another circuit court judgment. So
Well, there's a shot. He's so affable though. So
he is the nicest unorganized guy I've ever met.
If only he could sit still in a courtroom. It makes me dizzy the way he moves around. We'll be in a case that he has nothing to do with, and he's roaming in front of the bench, and I'm like, Toby, this is so.
He likes to move,
He likes to move. So yes, you are generally correct.